welcome back to the House Judiciary Committee this Thursday morning, May 21st. And we're going to be looking at an amendment from Representative Burdett and others. And Tom has chosen to be in the witness chair just to get a different view of the.
Let some people see my bald spot. Or my bald spot, yeah. It is a big spot.
All right, so tell us about it, and then we'll have Eric walk us through. I take it, or are you just going to walk?
No, Eric's going to walk us through it, and I have Jay Johnson from the administration here also to talk about it a little bit. But I think it's obvious where it came from, because 99% of this is language that we've already done a lot of talking about and vetting, and I one of the reasons I brought it forward, and I kind of talked about it a little bit this morning, is the fear that nothing happens. And again, I'm just going to repeat what I said this morning when we were talking about the amendment from the Human Services Chair, is that we study the heck out of stuff in this building. And, I mean, we're up to 40 something studies as far as, education goes. And it seems like we could probably do a little bit with something with some of those studies. But and what I said this morning was, are we going to get in line for a forensic facility as far as, the other projects go? And, we've talked about a women's prison for years. We've studied the heck out of that. We got a juvenile center that we need to build. We've studied the heck out of that, and nothing's happening. We passed a bill, not that I agree with it, but we passed a bill on, a safe injection site, and nothing's happened with that. And to take what the Senate had for a bill and basically turn it into another study, and nothing gets done, while the people that need to be, I don't even think the right word is incarcerated, but I'll say incarcerated, and getting the help that they need. I just think it needs to happen. And what this amendment would do, it would get an interim system set up until we can potentially build the building and the system that people have talked about in here. A state-of-the-art facility, I guess. And one thing that I really believe that needs to happen is this amendment puts DOC back into the picture. It doesn't put them in the building, doing treatment or security in the building. It's more perimeter type stuff to keep the public safe. And obviously with this population, the public isn't safe because of where they need to be. But that's the gist behind it. Again, is, do we just keep studying these things and having, and sending this population to, wherever we're sending them to? Some of them are in jail now. And not getting the proper help, I guess you can say. And in interim, yeah, there's going to be some mix of population, but right now it would be a better situation as far as the mix goes. I guess that's all I got. I just think it's the right way to go. Get a system in place. There's a lot of rulemaking in here. Things can be tweaked and changed as far as time goes on, but let's get that facility up and running and get the people in the place that's really secure, not just in a language that says secure facility, but a really secure facility with DOC as the buffer between the population and the public. That's all I got. And I appreciate the committee listening to me and taking this up. I feel real strongly about it. The way this all happened is unusual. I mean, I talked to the chair about it, unusual situation. I voted for the original bill, and then normally, I wouldn't bring up, I've never brought up an amendment like this against a bill that I'd already voted for in 16 years. And this is, I guess again, it was an unusual situation that all came about, but it's partly to do with that, but it's mostly how passionate I believe that we need to move this forward in a physical way and not just another study.
I'm just curious what, if you can describe what changed between the time you voted and the time and now bringing this forward.
Yeah, I can get into, I didn't want to, but I can get into that. The amendment that came down from I guess it's not from Human Services, even though the committee did discuss the amendment. And that was just unusual because we already voted on the bill. And I supported the bill. I voted for the bill, even though I wasn't crazy about where it was going. But I really think it was, no matter what happens, I think it's important that something moves forward. And at that point, I was hopeful to get on the conference committee and maybe make some of these changes, potentially. And another thing that I did is it was a unanimous vote that came out of here. And I'll say it right out loud because of me. And what changed with this, I looked at this amendment that came in. And it's hard for me not to look at it coming from the committee just because of the steps took. And it's a committee that didn't have jurisdiction over the bill, but certainly had as much say, more say about their part than we did. And I just thought it was too big and too much wholesale changes just to throw in there in the 11th hour as an amendment. And that irked me. And that's one of the reasons that I brought this forward, that I feel like I was pushed into a corner. And if I normally don't get real excited about things, I do once in a while. And this was one of those cases that I needed to push back on that. But I think this is, there's emotion involved in it, yes, as a lot of times there is in this building, but pushing the emotion aside, this is pure substance as far as I'm concerned.
But it goes beyond the scope of the amendment, right? Of the amendment that the non-human service would amend.
Yeah.
I don't know, we'll get a walkthrough.
I like that. Yeah.
Thank you, Chair. I just want to thank the Vice Chair. It's funny talking to you at this end of the table. I used to be looking that way, but I just want to thank the Vice Chair for the work that he's put into this and collaborating with the administration. And I know a lot of other interested parties, and it's not just you, it's not just the administration. There have been so many interested parties in this language, and kind of, I think for many of us, we feel like the pendulum has shifted, even this in the instances of this morning, hearing from Representative Wood and from the Human Services Committee, the pendulum has shifted so far to one side. I think, to me, this common sense and principled language is a shift back to the center. I think it's back to the original good faith negotiation that the 5 Republicans on the committee had with the chair and with the members of the opposite party. And I think to me, it's a really sad instance where we've really negotiated in good faith. We really did. And I think all of us, to the Vice Chair's point, we were not in support of the language as it was passed out on Friday, largely, but we did it in a vote of confidence for him and for the chair's leadership and the good faith efforts that have been going on behind the scenes with the other committees I won't call them committees of jurisdiction, but the other committees that had taken an interest in this bill. And contrary to what some people might think, it wasn't because the chair's wife was in the room. We genuinely wanted to try to get, and I love Ann Milan. I love Ann, but it's always nice to see her. But it was not Ann's presence that was moving Republicans to the center. It was really a belief in the chair and the vice chair, and I think possibly the chair of House Corrections that was, being floated as possible members of a committee of conference. So that's the point of frustration that I have is negotiations were had, we had a vote, the bill hasn't even been brought to the House floor, and then all of a sudden we have amendments flying. And I think that really, and I'm not the spokesman for the vice chair, but that's just kind of how I'm articulating. And to me, it feels like a personal slap in the face. I can't speak for the representative from Pittsford, but I would love to be included as a co-sponsor of the amendment, Eric, if possible, when it does come to the House floor in support of the vice chair and the hours of work that he's put into this. And so I think it's probably clear by my comments, but I'm in full support of the amendment and I look forward to voting yes.
Tom?
Yeah, I just I want to say everything that you've already said, but it's very important to me. I was unhappy about the turn that this has taken recently. I think it's very important as somebody who's been a practitioner in some of this stuff that when I know it's not a facility, but we're talking about here, but it's the chance to start testing what we need. And it's the opportunity to give help to people when they're, I hate to say the word, captive already. I mean, instead of doing dead time, we should be trying to help them, get them stabilized, competent, whatever we can do. And to me, it's worth its weight in gold to start that. It's also a test bed. We could learn from it for when we do build a facility, what we need to do. That's all I can say, I guess.
Appreciate it. So just a couple of comments before we get to walk through. So first of all, I'm going to start with the disagreement I have with Tom, and then I'll go to the agreement. I think it's okay that we did get the amendment. It seemed late from representatives on the human rights. That does happen. I do understand the frustration of it, but it does happen. We had to entertain it. And I do think that we need to find favorable. Putting that aside, I agree with underlying what we're trying to go. Tom and I are after the same thing, which I think largely. And that is we have individuals who are being held right now, we're languishing, and we can't wait years to get a forensic facility to help these individuals. And I felt that the corrections and institutions and other committees had come a long way by version 7.1 in actually putting in the feasibility study or plan that DOC, we would look at what we can do in the interim. At that time, I felt we needed more, and I felt that, and I still feel this, if this isn't the path we're going to go to and we get to conference committee, that's my focus is we need to have DOC much more involved, at least initially in the interim, because otherwise these people are going to languish. And I think this does that, but there, but there are bigger issues beyond just this committee and bigger discussions. So I do want to have the walkthrough of this, and I'm going to just postpone the vote for a while because I do need to have some other discussions, because it does have some of the fundamental things that I think we need to be doing. And I think this whole committee has felt that as well, is that there is this interim and it's going to be a while to establish this facility as it's structured here. We need to do something more for the individuals that we're currently holding and for the victims that are dealing with these individuals that we're currently holding. So I do have that agreement, but why don't we do a walkthrough of this?
That's great.
Figure out.
Thank you. Appreciate it.
Thank you, Tom.
Yeah, I had mentioned.
Morning, everybody.
Good morning, Eric.
Eric Fitzpatrick with the Office of Legislative Counsel. I'm here to talk now with the committee about a proposed amendment from Representative Burdett and others to S-193. I just had a bit of deja vu. I think I was not long ago talking about a different amendment. Hopefully I won't get it mixed up with whatever previous one I was talking about. So we'll try and focus on this one. I don't know if everyone has in front of them. It may be helpful at certain times to be able to look at both version 7.1 and the amendment. You have them both, that way you can, I can explain it, but it would be, sometimes you might find it easy. So if you,
Is it possible to get 7.1 on the screen? And we all have the amendment.
I'm also gonna repost it
Okay.
as well.
Thanks. Yeah. Seems good.
yeah, good idea. Thank you.
So is it good enough just to have it reposted that you'll look at it there? Or
I guess that's fine.
Okay,
Yeah.
all right, if that's easier. Okay.
Fine. So should I wait a minute or?
You can go ahead, Eric.
Yeah, okay, all right, yep, thanks. Okay, so as Representative Burdett was saying, just to give you a couple of big picture.
Yeah, can you just, are you able to put it on speaker for me? I just can't find that.
Looking for it on the screen.
Okay, nice.
Barbara.
Oh, you want to see it on the screen, Barbara?
I don't know if you can put a Zoom call on speaker.
Barbara,
Not on mute.
thank you. All right. All right, go ahead. Eric, back to you.
On the big picture, as Representative Burdett was saying, this proposed amendment that you're looking at both takes away, removes some of the language that was in version 7.1. I think much of it having come out of other committees that limited the role of Department of Corrections. I'll point you to that, but remember that was some limitations on the scope of what DOC could do. So that language is repealed in this amendment. And similarly, when you're talking about who it is that's supervising the person, for example, when they're released from the forensic facility, you had moved in the direction of in version 7.1 of that supervision and notifying the court when the person comes back into the facility. All of that was by departments within the Agency of Human Services, but not the Department of Corrections. So it was all the other departments that were going to be taking on that role. So the other thing, one of the other things that's going on in this amendment is DOC is reinserted into that role, so that the supervision you'll see is by DOC in collaboration and consultation with the other AHS departments. So those are two, you'll see that multiple times as we go through it. But I say that so that, then when I say, oh, that's another example of adding DOC back in, you'll know what I'm referring to. And lastly, the other big picture thing we'll get to at the end, you may recall that the feasibility study included kind of an interim provision of competency restoration services to this population, and an interim it could be provided by DOC. Remember, that language is in 7.1, that it was in the feasibility study. So what this does is it takes it out of the feasibility plan and instead puts it into rule, and so that it can become operational more quickly, so that you will, the idea is to have this interim provision of competency restoration services and other forensic facility services to people who are within this covered population prior to the actual permanent forensic facility coming on board in January 1st, 2028, I think is the current date. But the other thing you'll see when we get there is those dates can always be changed by future legislators if you need to, depending on how quickly everything gets on board. So that's the big picture. All right, so let's look at the amendment language. So if you look at the first instance of amendment, this is to do with the legislative intent is the, can't remember. Okay, so, but everyone has a document, or you can look at 7.1 if you want. All right, so all this legislative intent is the same as it is in 7.1, except for the deletion of one sentence. And if you look at your 7.1, probably if you're looking at the same version, it might be line 13. Does everyone have a line 13 on page one? And you see a line. What's that, sorry?
You have the lines memorized?
No, I wish. Yeah, that's a bar I can never reach. But, if you look at line 13, page 1, there's a sentence that starts, the Department of Corrections shall not operate or staff the forensic facility, with the exception that employees of the Department of Corrections may provide security services for the facility at the admitting area and around the outside perimeter if it's co-located on the grounds of the correctional facility. So I'm sure the committee remembers that. We talked about that language, and that appears several different times in 7.1, and each time it appears, it's struck. Because obviously it would be contradictory to say that and to also say, as the amendment proposed to say, hey, DOC actually does provide supervision while the person is released, that sort of thing. So everybody see that? So it just strikes that sentence. That's the only difference in section. Sorry, instance of amendment 1. All right, so now we go on to second instance of amendment. If you look at page, now I'm on the amendment language, right? And all you need to see here, you don't need to toggle back to 7.1 for this. Just look at page 1 of your amendment, line 18. And this is about when, again, as I just mentioned, the person's being released from the forensic facility, and when they're released, they're being supervised. In this case, it's somebody who's been found non-restorable and not dangerous, right? So this is the category that you're in: non-restorable, not dangerous. They get released. In that category, you'll see the proposed new language is line 18. They're released because if you sort of imagine that language not being there, it would have said they've been released under the supervision of DMH, Dale, and Department of Health, right? But instead it adds released under the supervision of DOC in collaboration with the other departments. Everybody see that? So that's the difference there. Similar over on page 2, same thing. This is all part of.
And that's questions.
Yeah.
I'm going back and forth between 7.1 and the amendment
Okay.
of Tom's, just call it Tom's amendment for right now, right? We're going, switch it back and forth.
You can. Yeah, this one you don't really have to, but you certainly can, because all the language happens to be there in this instance. But still, yes. Go
On
ahead.
the amendment?
Yep.
Okay.
So in this one, you don't have to go back and forth, just because sometimes the way we write amendments, you repeat all the language in the amendment, so you don't have to jump back and look at it. It's just sort of.
I'm not jumping.
Okay, that's right. So there, you see the language. There's no need to switch back and forth on that one. This is a situation where someone's being supervised on release, and instead of them being supervised by DMH, Gale, blah, 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 it's supervised by DOC in collaboration with those same departments that were mentioned. So one, same thing on page 2, which is related to the same release. This is the court order related to that release, because the court has to order that they comply with these conditions. And again, it's just the same change, lines 3 and 4, adding in supervision by DOC in collaboration with the other departments. So, and the actual entity doing the supervision is the DOC, and that's also in the third instance of amendment, lines 7 through 10. You'll see who's supervising the person upon release. And it's not DMH, Dale, et cetera, because the entity that's supervising is DOC. So that's why it inserts corrections there instead of the others. Similar again in subsection G, which is the fourth instance of amendment. Go down page 2 to subsection G, starts on line 14. This is who monitors compliance. Because remember, there's also that piece about someone's going to monitor compliance with the conditions of supervision, because then if it turns out the person isn't complying with those conditions, they can let the court know, and the court can bring them back into the forensic facility. Remember that? So this is all right. Well, who's monitoring the person? Here, you'll see what's added is that the Agency of Human Services medical director, in consultation with the various departments, is the one monitoring the person, because that makes some sense, because it's the medical director who then has to, over on page 3, line 3, this is the existing provision. They're the one who has to think that, hey, due to a qualified condition, the person's continued release might create a substantial risk. So they're keeping an eye on them, active compliance, while they're under release. And then this is line 18, if they make a request to the court, then the court brings them back into the forensic facility, and then the court has to have a hearing, because they can't just keep them there solely on the basis of the medical director's say so. The court then has to have a hearing and say, oh, all right, well, there's clear and convincing evidence that the person's dangerous, etc. So that's the way that works. Again, I just mentioned this already, the fifth instance of amendment, page 3. That's who notifies the court when the released person gets returned. Remember, if someone has to let the court know, that's the switched from the commissioner to the Agency of Human Services medical director. So they let the court know, hey, this person who we were monitoring back in the facility now. The sixth instance of amendment, you see page 3, starts on line 9. This is all the exact same thing that I just talked about with respect to the NGRI population. I just talked about it with respect to the competency to stand trial. This is the same thing for that. So it's the medical director who monitors, see line 15, it's the medical director who lets the court know that the person is, who notifies the court if the person's not in compliance, and then the next sentence, line 19, notify the court if the person is recommitted, basically. Let's see. So that brings us over to page 4, seventh instance of amendment. Starts on line 5. This is a different topic. This has to do with the inclusion in the, this is the definition of forensic facility. Remember, the definition said it's a secure facility licensed as a therapeutic community residence. So this proposes to strike that and instead just say that provides a suitable clinical setting. I don't have a great deal of expertise on that's more of a Katie issue, the TCR, therapeutic community residence issue, but the proposal is to require a suitable clinical setting rather than specific like the residence. All right. Yes.
Thank you, Chair. Quick question on that. Gail would still be the one responsible in determining what is suitable. Gail would still be the one making the determination of what a suitable clinical setting is. That jurisdiction doesn't change.
I think it's true that who makes the determination will be within the Agency of Human Services. It may be that it would depend upon the person's condition.
Sure.
So Gail would make the call, yes, if it's intellectual disability, developmental disability, that kind of thing. But if, on the other hand, if it's more of a,
It'd be the administrator of the facility,
Exactly.
whoever it might be, that would make that final determination
and the department, that's
itself.
yeah.
Okay, thank you.
Yeah. Eighth, you'll see is just another striking out. This is from the general structure of the forensic facility, starting on line 9, some general principles about the forensic facility that are in the definitions section. And you'll see that's a proposal to strike out a sentence. So if you look at 4026 subsection B, just as I mentioned at the beginning, when I mentioned this the first time, it disappears several different times. This is another one of those times in this general discussion about what the forensic facility is. Subsection B, I'm on page 20 of version 7.1 if you happen to look, but there's a sentence in there that says,
That again? What page?
I'm on page 20 of version 7.1. Yep. And this is, so it starts on line 10 of page 20. This is some about the forensic facility. Secretary of Human Services established and operates this locked secure forensic facility. And then in the second sentence starts on line 13, forensic facilities, clinical, forensic, and competency restoration services overseen by the medical director, right? That stays the same. None of that's changed. It's that last sentence, well, second to last sentence, that's struck in the proposed amendment. The Department of Corrections shall not play a role in the forensic facility's operation, provision of services, or internal security, except for security services at the admitting area and around the perimeter. Again, exact same sentence that was struck in the legislative intent in section 1.
Yeah.
Again, it's that limitation on DOC's involvement that is proposed to be struck by the amendment. All right, so that's the eighth instance. If you look at all right. I'm just making sure I have this checking out therapeutic community resident. Oh, yeah. Okay. All right. Sorry. So in subdivision B1, this is also these general principles by which
Eric, where are you now?
I'm on the amendment. It's page 4,
Okay.
line 14. And it's the same issue that I mentioned earlier, therapeutic community residence, going away from that description, instead saying a suitable clinical setting. So it's saying the forensic facility has to be designed and operated in a manner that supports therapeutic, recovery-oriented, and trauma-informed programming in a suitable clinical setting. That's what it would say, rather than in a therapeutic community residence.
A suitable clinical setting could be a therapeutic community.
Could be, yeah, sure. Yep, it would again be, I think, up to the appropriate department to decide what was suitable.
Oh, sorry.
I just double clicking on the point the vice chair is making, changing that language actually provides more optionality in terms of where the services could be rendered and the type of services. Isn't that right?
That could be, and it seems to make sense, but because I don't have that expertise, background knowledge in what a therapeutic community residence actually is and how it works and function, I can't really say for sure, but
That just seems to be a more narrow description, whereas as we broaden that out, it seems like we're actually increasing the services that could be rendered here on that path to restoring competency,
yeah,
which I think is a really encouraging thing.
And it does
It's a great
get
change.
broader depending on definitions.
It's a great change.
and it could also be, again, this is in a way outside my lane because this was more Katie's area. But I do recall her saying, and it being discussed, that the rules regarding therapeutic community residents would have to be modified in order to have it really fit the forensic facility structure and population. So it could be that as a result of that modification, they would broaden it in the way that you say that you're kind of getting at. That this sort of does it sooner because you don't have to do the rule to do it. But again, that's my reading of it, not necessarily.
Thank you, Eric.
Background. Yep. So that's where we are there. We're striking out that language, therapeutic community residents, right? So then we're also in this general provision about the forensic facility itself. You may recall, and this is, if you want to look at version 7.1, this is on page 23. It's subsection E, which is line 11. And this is, remember, just sort of a general statement. The Secretary of AHS has to consult regularly with all the commissioners of the various departments when performing all their duties required by the statute. And this just adds in the 9th version of the amendment that they also, in the 10th version of the amendment, they also consult with the Agency of Human Services Medical Director. Just adds them to the list of consultees. All right. Now we come to several sections of amendment that are actually maybe one ahead of myself. All right. What's one ahead of myself? So this is some modifications to the forensic facilities section, which is section 7, which starts on page 24 of version 7.1. So I'll ask you to look here if you can do that. Version 7.1, page 24. And this is that feasibility plan, remember? So again, striking some of the same concepts that I've mentioned a couple of times already, both from the legislative intent and in the way that the facility is run. Also similar concepts that are proposed to be struck in the feasibility plan. So if you look at page 24, line 19 or so, well, we could start at line 17. This is some general statement. The feasibility plan shall assume that the operation, staffing, and programming at the facility shall be provided by AHS or its departments. And then you have that limiting language again, starting on 19, with the exception that DOC shall not play a role in operation, et cetera, other than provision of security services. That sentence, once again, is struck in the amendment. So if you look at the amendment, page 5 of your amendment, line 10, right there was where that sentence would be, but it's not because it's struck again. Same idea, same concept. Similar idea if you keep on page 5 of the amendment. If you look at Roman numeral 1, line 12, you see that? The proposed location of a forensic facility has to be in the feasibility plan. Everybody see that? Struck language here, I'll just read to you if you want to look at it. It's on page 25 of version 7.1, lines 4 to 6. That contained language that said proposed location of a forensic facility, comma, which shall be independent from a correctional facility, and if on the same grounds as the correctional facility shall be separated by sight and sound. So that, again, this idea of removing some of these restrictions on DOC involvement is done there as well.
So that was struck.
Correct.
Okay, gotcha.
Yep.
Thank you.
Yep. One other thing, or the next thing I should say, turn for a moment on your 7.1 to the next page.
The good thing I got a highlighter.
I know, I use that too, definitely. If you look at page 26 of your version 7.1.
7.1 is gonna be in my head all night.
Eric, can you say again? Where are we in 7.1?
Page 26. So a couple of things here. You'll see that in subdivision 10, which on your version 7.1 starts on line 5. You see once again that language. If you look at starts on line 7. It's talking about generally the plan. It says, which shall not involve DOC with the exception that employees of DOC may provide security services, et cetera. Should be familiar to you by now. Every time that comes up, it's struck in the amendment, so it's struck here as well. So this statement that it shall not involve DOC, starting there, that language is all gone, because if you looked at your amendment, page 6, line 10, subdivision 10, that language is not there. And lastly, you'll see, again, if you look at the version 7.1 starting on, on page 26, there's that subdivision 12, starts on line 16. This was that interim program that I had mentioned when I was talking about this at the beginning, because the feasibility plan called for opportunities and the feasibility plan to address opportunities and cost estimates. This is line 16. For persons who would be eligible for placement at the forensic facility to receive the following services while the development of a forensic facility in Vermont is pending. So you see the concept there. This is to create some similar kind of competency restoration services available, because obviously there may be people who would qualify for this in the meantime before the facility is actually up and running. It doesn't have even an effective date till 2028. So subdivision 12 provided in the feasibility plan to try and have that address how these services could be provided in the interim. So that struck entirely from the amendment, and instead segues us nicely in the amendment over to page 7. Instead, the approach it takes is to require it by rulemaking or quickly rather than waiting for the feasibility plan to come back until January 1st. So instead, you'll see section 9, this is all new, although interestingly, it's new, but some of the substance is actually the same as the rulemaking language that was in the version that passed the Senate and which was in a prior version that this committee had been looking at before it was struck. So you may recall that you've seen it before, at least some of it. Although the difference between what you saw before for rulemaking and what you see now is that this is specifically targeted at, say lines 13 and 14, starting there of the amendment. So it's page 7 of your amendment. So again, this says on or before December 31st, 2026, Human Services in consultation with all the departments, now I'm on line 13, shall adopt emergency rules. So that's a difference. In the first place, it's emergency rules, have to be quicker. Line 14, to establish an interim forensic facility and competency restoration program that shall operate pending the completion of a permanent forensic facility. So you see that's wasn't in the rulemaking language that you looked at before, because that was very general about adopt rules for how this would work, where this is specifically targeted at rules on an emergency basis to address the interim competency restoration services idea. So that's the idea. It says, then you start on line 16, emergency rules shall establish, and I added this, for the interim forensic facility and competency restoration program, we can just talk about, and consistent with the standards of sections 1, 2, 4, and 5. That's to give the agency some guidance as to what standards these rules should be in conformance with. And then that substance, clinically appropriate standards governing services over on page 8. And that language actually is identical to what was in the rulemaking before, same as subdivision 2, standards of quality assurance and improvement, et cetera. At subdivision 3, page 8 of your amendment, victim notification procedures, that I believe was added in health corrections initially when you were looking at rulemaking. Subdivision 4, any other provisions necessary. And then a key point, bottom of page 8, subsection B, these emergency rules shall be repealed on January 1st, 2028. That's because that's the effective date of the permanent facility in the other sections. Bear in mind, not trying to jinx anything, but if for some reason, January 1st, 2028, it's not ready to be up and running yet, you can always just go back in and change that date. Because that, you think about it, you'll have another legislative session. Look at that before that date comes up. So it's kind of reminds me of raise the age a little bit.
A lot.
Should that be considered a sunset other than just the date? Because I know with sunsets that you usually go through them every year to see what's coming up. I don't know if this did go forward.
I thought about that,
I
and
didn't know if it could be missed if it's not a sunset.
yeah, and I thought of that, and the reason that I decided not to do it that way
Yep.
is because you don't necessarily want the rules to all of a sudden disappear in that way. You know, if they're being repealed, you have a record of it right here, a separate sunset section. You're right, we do internally in our office keep track of sunsets. But here, with it being embedded right there, I don't know, you could go either way. There's not a wrong answer.
I will go with whatever you.
Right. But I think you're right that conceptually, that's what it is.
I just raised the flag.
Yeah, no, it's true.
So can we just back up? You said on page 8 here somewhere, I think it was house correction added language. Where was that? I missed that.
That was line 6 to 13. That was that the rules would address victim notification procedures. I think
Okay.
this committee, I remember we looked at it. Yeah. Yeah, I think you had a
It
role.
was house corrections and us.
Yeah, I misspoke there. Sorry. I think it was this committee.
That's okay. Thank you.
That's one more area.
Yeah.
And actually, this isn't so much a question, just a compliment to you on the way that this was constructed. Because I think, one, it's beautifully done, and I think, and secondly, the expediency that this adds to the bill of giving a deliberate timeline and really instructing the secretary in the respective agencies to collaborate and to move this solution forward. Because I think that's one of the things that many of us that had concerns were where the bill was and where it would be with the Wood Amendment and et cetera, is that there still is a problem that we're looking to solve. And I think, one of the comments that I've made in the testimony leading up to this is that we want to continue moving the ball downfield. And it seems like this is a really beautifully constructed solution to that. And again, I appreciate how expeditious this is going to be to addressing the public safety crisis for this impacted community. So just a note of thanks and a compliment.
Well, thank you very much. I certainly can't take all the credit for that. Working with obviously the sponsor of the amendment and the counsel for the governor, all were, so I may have put some spin on the writing, but to defer the ideas as well.
Yeah, it's terrific.
So one comment, if this were to go through, I would suggest that sections 1, 3, and 4.
Are you on the amendment?
No, I'm not, I'm talking about 7.1.
Okay.
I would suggest that section 1, sections 2, 3, and 4 would go into effect when the rulemaking is concluded. Because we need to have all those due process, that process for who goes in there. That shouldn't take effect in 2028. It should take effect in the interim when the rules get put into place.
And make sure those don't sunset.
And yeah, they wouldn't be in sunset of those. You understand what
I do, and I'm thinking on the fly, but so that means you would have, let's say the rules became effective on just January 1st, 2027. Just to pick it now, just for the sake of trying to think this through. So section 2 was then in effect. For example, look at subsection A, page 2. Person shall be placed at the forensic facility established in section 4826. Well, that wouldn't exist yet.
Right.
So I'm not sure.
Understood, yeah. So
But that's why I think that
there would have to be some tweaking.
right.
But I also think you kind of need to have that in place because to know who would be getting those services, even if it's in the Department of Corrections.
I think the intent, maybe here's where we could do the tweaking, was to cover that by page 7, line 18. So that this interim program has to be consistent with the standards of those sections.
Oh, I'm sorry. Okay.
So that way, the same principles would apply, even though the facility, the permanent facility itself isn't yet in. But think about it. I mean, that was it. Maybe there's a better way to do it, but I see what you're saying. You're right. And that was the way to try and incorporate that.
Yeah, that's sufficient. Yeah. And
Do you think that's it, or maybe like standards and procedures or something?
Sure,
If there's
yeah,
one other word to make it very clear that.
yeah, yeah.
Because it's not just referring to like the eligibility standards and stuff, it's really talking about all that due process stuff, and I think that's procedures or process or something.
Yeah, I think that totally works. Same idea.
um. Yeah.
So I just want to point out that I pointed out, well, first of all, I want to say probably for the first time ever that I'm not spinning my head with going back and forth
Okay.
to what Zach said about following stuff. You did an amazing job with this and these amendments and stuff that put that together. So it was easy even for me to follow, which is huge. The other thing is I've been saying for years, 8+ years, that we need some way to help the people that need help and the victims' families. And I figured I was not happy with these amendments that came before us before and all the entities that brought all this up when again, not to give the chair credit, but I will, that brought us all together to make this happen. We need a starting point. This seems to bring it together, unless I'm missing something. I don't think I am. This finally gives, I think I just said this, but it gives protection to the individual and public. It's taken way too many years to get this to this point, but hopefully this will go. And the biggest thing is it's a starting point. And like I say, I think everybody's been so hung up on having exactly what they want, how they want, right straight out of the gate, that they keep missing the word that we can always tweak it as we go to make it better, because our job is to make things better for all Vermont. And I think that's what this does. And that's as far as I can go with my niceness.
Thank you. Appreciate it.
Coach. And then that.
No, I'm just,
Oh,
I'm the
sorry.
thumbs up to my colleague across the table.
Oh, yeah. Coach.
Okay.
This is a question for Eric. Being that we've gone from version 1 through 7 and now 9 instances of amendment, do you recall when we were talking about DOC being more involved, that specific cohort, which is probably going to be a limited number of people, as far as staff people, correctional officers, will they be getting specialized training to deal with that population?
I don't recall that training issue specifically being addressed. I do recall that the commissioner of corrections saying that from his perspective, they could cover this population given the numbers, but that was kind of a general recollection that I have. I don't remember anything specific about training.
Okay, because for me, I understand all the changes. I can wrap my head around why and how, and especially the public safety aspect, and concern with everything that's going on in the world right now. So my, I know, Ken just mentioned the over detail component, but that's critical. You don't want someone who doesn't understand doing oversight. So having that small team, however many, would be, I think that's that's important. You know, I just needed to put that out in the universe.
A question for Eric, kind of along those same lines. In the earlier version, didn't DOC have more, I guess what could potentially be more contact with the population, and we separated that and put it more into the, I'll say, the human services world, and purposefully pulling DOC away from that contact where they were mainly just security.
Yes, in fact, as it came over from the Senate, it was just DOC. We weren't really naming on these, because the way it's now, it's still under the umbrella of AHS.
Right.
And in consultation with the other departments, it just sort of includes, this proposal includes DOC back within that process. But yes, I think even a step prior to that version as it came from the Senate and as what this committee was looking at earlier was really just DOC.
Right, yeah, and I think we purposefully separated DOC from having anything to do.
I know what you're saying, with the services provision.
Yeah, with the
There's still
services
there's still that sentence in there that's
expertise.
right. That's still in there about how that it's the forensic facilities, clinical, forensic, and competency restoration services shall be overseen by the AHS medical director. So I think that's the distinction that this committee worked out.
Well, you know, that part I understand. But someone raised, oh geez, it was sometime last week, you know, about what if something broke out? You know, there was an incident where, you know, there was folks just kind of lost it, you know, in the cafeteria, you know, at the facility, for example, if they're all eating, you know, together, and the OC needed to be called, you know, in for that security piece to assist the rest of the staff. You know, I think you would want those people to have, you know, specialized training, you know, in de-escalation and all of the other pieces, you know, that would go with it, because there are national standards for those trainings. So anyways, it was just a thought, just had to get it out there. Thanks.
So I didn't think they were part of that, I think I brought that up if there was an uprising, but that was, you know, not the eating facility, because as I understood it, they weren't going to be eating at the same time and all that. But I just want to feed off from what Vice Chair was saying about the training. Now that we brought in, or the other entities now know that they are definitely part of this, that are running this. I mean, they're already trained in handling the care and all that stuff. It's not like we're sending out additional care people or anything like that. They're already trained. So that part, that's a non-issue. That's a non-starter. It's already there, right? Not missing anything.
Well, you know, from that, you know, that perspective, but you know, having it co-located, like more than likely it's gonna occur. You know, just based on all of the evidence we've heard over the 7 versions.
Yeah,
You
but
know,
I think you and I are talking two different things, Coach.
well, not necessarily. I think we're closer than, you know, you'd think.
Tom Oliver, then Tom Burke, then we need.
Yeah, I just, we can do from some experience. I think they do have extensive training in de-escalation and dealing with people that may or may not be competent, et cetera. And, because they're already taking care of them now on a daily basis, and there's expectations of that. But I think this would also be beneficial to have the Agency of Human Services, the Department of Mental Health, up that whole level of training as they collude on this operation, you know, what they're going to need inside their facility or domain.
That's what I was getting at, Tom.
Thank you.
All right, so we are going to vote on this eventually and the Wood Amendment, but not right now. So stay. I will let folks know we're until further notice. So sometime this afternoon, one way or another, we'll be voting on these two and try to get 192. We're all right. Thank you.
Should I